Good morning, and thank you for joining us. On behalf of the Chicago Lawyer Chapter of the American Constitution Society and Northwestern Pritzker School of Law, it's my privilege to welcome you to Appealing for Change, Diversifying the Appellate Bar. I'm David Shapiro, a member of the ACS Chicago Board, a faculty member at the Northwestern Law Bloom Legal Clinic, and the director of the Supreme Court and Appellate Program of the MacArthur Justice Center, an organization that litigates to protect and enforce civil and human rights throughout the United States. Increasing the diversity of the appellate bar is a vital and urgent undertaking. The extensive list of co-sponsors for today's event underscores the energy and momentum that surrounds this important and long overdue transformation. Among ACS chapters, we're grateful for co-sponsorship by the DC, Madison, Michigan, Milwaukee, New Orleans, Northeast Ohio, Orange County, Philadelphia, Sacramento, San Diego, Tampa, and Virginia lawyer chapters. We thank the Illinois co-sponsors of this event as well, the Asian American Bar Association of Chicago, the Women's Bar Association of Illinois, and the Hispanic Lawyers Association of Illinois. And we are grateful to the Northwestern Law Student Group co-sponsors, the Northwestern Law ACS chapter, the Asian Pacific American Law Students Association, the Black Law Students Association, the Latino Law Students Association, and the South Asian Law Students Association. Today's panel is moderated by an accomplished leader who has spent her career fighting for fairness and inclusion, both within and beyond the legal academy. Shannon Bartlett, Associate Dean of Inclusion and Engagement at Northwestern Pritzker School of Law. Associate Dean Bartlett will introduce our illustrious panel and lead the discussion. Thank you.
All right. Thank you very much for that introduction, David. And also, I also want to thank David. This panel was his idea. He thought it was an important conversation to have. And so kudos to David for thinking that this is a topic that's really important to be heard and for gathering a really amazing panel that I've enjoyed getting to know as we prepared for this conversation. So it's my pleasure to introduce our panelists who are here with us today. First, we have Brad Garcia, who is a partner at O'Melveny & Myers. We also have with us today Beverly Jones, who is an assistant appellate defender at the Office of the State Appellate Defender here in Illinois. We also have with us Javaria Khan, who is founder of the Appellate Project. We also have Sopin Shah, who is an associate at Perkins Coie. And I personally am very excited to have with us today Judge Anne Claire Williams, who is of counsel at Jones Day and a former circuit judge at the U.S. Court of Appeals for the Seventh Circuit, and who has been such an inspiration for so many of us, lawyers and law students, as we've navigated the profession. So I'm truly delighted to have her here to share her perspective as a student, as a lawyer, and as a judge. So with that, we'll go ahead and get started with our conversation, which is focused on the importance of diversifying the appellate bar. And so I'm going to start with you, Judge Williams. We'd like you to hear from all the panelists about your particular path to appellate lawyering and how your experience has shaped your view on the importance of diversifying the appellate bar. So I'm kicking things over to you, Judge Williams.
Well, thank you, Shannon. And Shannon, thank you. And it's a pleasure to be here with all of you today, and for us to have what I hope will be a rich conversation. So for me, the story of how I got to my Seventh Circuit clerkship and ultimately made it to the Seventh Circuit, I'm first generation lawyer. I was in total ignorance when I started law school. I rolled to law school the day before classes started. So when I say total ignorance, I didn't know I had books. I didn't know I had an assignment. I didn't know anything because, of course, I grew up on Perry Mason. I knew about Thurgood Marshall, but Perry Mason was the lawyer that I knew. And so I did nothing to prepare what I thought for that clerkship on the Seventh Circuit. I, unfortunately, in my first year, was invited to join the moot court team, and I was asked to be assistant director of Legal Aid Society. Legal Aid Society spoke more to my interest. I turned down the moot court. Big mistake. I was asked to write on to the law review. No, I chose to do legal aid. So when the dean called me in my second year and said that the Notre Dame graduate, Luther Swigert, who was the chief judge, was looking for women, and in particular was looking for Black women who were capable and strong and had the grades to be a clerk, the dean called me in, told me about Luther Swigert, asked me if I had thought about clerking. And, I'm always as honest as I can be. So in that time that he described it to me, I did think about clerking. So when he said, have you ever thought about clerking? I said, yes, Dean. I had not thought about clerking. I didn't know the value of the clerkship. I didn't know the imprimatur that you get if you do a great job, how that is a golden ticket to open the door to other things. And I then came to the realization that those of us that are first generation haven't had the exposure that we need, nor do we understand the importance of the clerkship and the importance of appellate lawyers. Because where were the victories of civil rights lawyers? In the appellate court. Where were the victories of Ruth Bader Ginsburg? In the appellate court. Of course, it had to start in the district court, but it rose to the appellate court. And so for me, that light bulb, recognizing that most first generation, many kids of color, the light bulb goes off at the end of the first year when there are opportunities that we have not taken advantage of. So it had a tremendous impact on me. And that's part of my mission in life, to not have people come into law school the way I did. Now, it turned out my story ended up being a great story, because after the clerkship, I went to the U.S. Attorney's Office and I argued before the Seventh Circuit, then was in the district court and ended up at the Court of Appeals. So that's my journey. And that's why I'm passionate about expanding the number of people of color, first generation, underrepresented groups into appellate practice. It really matters.
All right, thank you very much, Judge Williams. And so I'd like to open the floor, and we would like to hear from all of you about your path to appellate lawyering. And so whoever would like to go next, just chime on in.
I can go next. Hi, everyone. My name is Beverly. Thank you to allowing me to be a panelist today. My appellate law journey didn't start until law school. I didn't even really know about appellate law or anything like that until I got to law school. I knew that I wanted to practice in the area of criminal law. And for those who are not familiar with the Appellate Defender's Office, the office handles criminal appeals. And so I knew I wanted to work in the criminal law realm, but how I came about appellate law was through my evolving interest in legal writing and analyzing issues and emerging case law that I found to have enjoyed when I was in law school. And then that led me onto the track of appellate law. And just as Judge Williams mentioned, you learn that the cases that and the decisions that come out of the appellate court and the Supreme Court are what shape our everyday life and the laws that we follow and are governed by. And so diversity in appellate law is very important in making sure that everybody's voice is heard and that we are all living cohesively under one law where all of our rights are being upheld.
Thank you, Beverly.
I'm happy to jump in. Thank you all for having me here today. I would echo a lot of what Judge Williams and Beverly shared, in that I didn't know about appellate work until later on. My interest in the law initially really stemmed as someone who's first generation from, I grew up in a pretty rural, small environment, and got curious about the law because of 9/11 and seeing its impact on my community. And that sort of led to learning more about history and the history of marginalized communities using the courts as a way to assert their basic rights. And many of the rights that I do have are through that process. That led me to law school. I certainly didn't know about clerkships or appellate work. It was a few years into practice when I started doing impact litigation that I started to meaningfully understand the importance of appellate spaces. They these appellate attorneys are the ones who get to shape the arguments, choose the facts that are presented. It's a conversation with the court on how the law should be and how it should impact all of us. And it was very striking to just see how the conversation would change when attorneys of color were in the room. Those attorneys not infrequently go on to become judges or have other, significant appointments where they're in a position to shape laws as well. And when we're thinking about appellate courts, what struck me most is just these are matters of law, right? There's no juries, there's no additional fact finding. So you have a group of people who are engaging in this deliberative process together. And when you don't have diversity, especially racial diversity in those spaces, you lack that lived experiences and perspectives that everybody brings and is so necessary to reach a decision that's equal justice under the law, right? It's going to impact all of us. So it was really just seeing how the conversations would change and the impact of that lack of diversity on the law being shaped as well that really drives my interest in this issue.
Thank you.
I can hop in next. Hi, everyone. I'm Sopin, and thank you so much to everyone for inviting me to be a panelist on this very important topic. And like many people who have spoken already, my path to appellate lawyering also began after law school. If you had asked me in law school whether I wanted to be an appellate lawyer, I probably would have said no. It seemed like something that people pursued for its own sake, and I thought it sounded sort of boring and maybe isolating. And I was definitely wrong about that, as we'll discuss later. But it wasn't until my clerkship on the Second Circuit that I started thinking that I would want to practice appeals. I found oral argument really interesting. I saw, as many people have already said, that appellate courts are where rules are made, where laws are made. So when I saw that Wisconsin, which is my home state, had a Solicitor General's office that did exclusively appeals, and I wanted to move back home after clerking, I applied and got a job there and started briefing and arguing cases in the Seventh Circuit and in the Wisconsin Supreme Court. And that's when I really started to notice the lack of diversity in the appellate bar. Often I would be the only woman of color in the courtroom, let alone the only woman of color presenting argument. And I thought it's important to have diverse appellate practitioners for many of the reasons that people have already discussed, the unique insights that diverse people can bring to the case, the fact that diversity leads to better and fairer outcomes. But I think it's also necessary, as Javaria said, to diversify the set of people whom we consider leaders in the law. And when you argue an appeal, when you speak in a courtroom, that's sort of the lawyer's time to shine. So when diverse lawyers get those opportunities and perform well, that leads to promotion, to publicity, to all of the things that make the case for, if you're at a law firm like I'm currently, that make the case for partnership or promotion easier. So it's my hope that a more diverse appellate bar will lead to a more diverse law firm leadership and general thought leadership in the law.
And I'm Brad. Hi, everybody. I'm also very happy to be here, and I will, briefly say that I definitely echo a lot of the sentiments that have already been expressed. I think that, my path to appellate practice is probably what people would think of as more, traditional. But I also, when I went to law school, didn't know what a clerkship was or the difference between appellate practice and anything else. And I was fortunate to have a professor encourage me to pursue a clerkship. And after law school, I clerked at the DC Circuit and then at the Supreme Court. But that gave me a perspective on a lot of the points that others have been making, which is that just the lack of diversity in those spaces, from the clerks to the judges and to the attorneys, is really striking. And as a lot of the other panelists have already said, the fact is that the cases that these courts are deciding are hugely important, whether it's criminal cases, voting rights cases, anything you can imagine. And it affects every community. And the fact that there is such a lack of representation, I think, is, for all the reasons everyone has said, is an obvious problem. And I'm excited to speak with you all today about why I think it's important that that more folks from underrepresented backgrounds get involved in this kind of work.
Thank you all for sharing your journeys to appellate lawyering and talking about the importance of having diverse representation in the appellate bar. Brad, that was a great segue to the next question, which I'm going to kick off to you, which is, as you think about your career in appellate practice, how have you seen having more diverse representation on appellate litigation teams? How have you seen that promote better outcomes and litigation strategies?
Sure. So yeah, and I think that diverse representation on all legal teams, including appellate teams, is sort of essentially a value in and of itself, but it also definitely can lead to better outcomes. And the one example that I wanted to share about that is actually not about me, but I served as sort of the legal expert in a case that our firm brought on behalf of 4 Muslim federal inmates who were seeking religiously appropriate food from the Federal Bureau of Prisons. And, I brought sort of my legal expertise, such as it is, to that team. But it was also, for this question, it was hugely important that we had a Muslim attorney on our team. So he had a baseline of background knowledge that made our arguments better, helped us understand the different issues, and it clearly mattered to our clients. And I think that, others will definitely be able to speak to this even better than I can, but the value to both the courts and to your clients of having, a variety of backgrounds on a team is just is hugely valuable.
Thank you, Brad. Anyone else want to offer perspectives on how you've seen having diverse representation on your appellate teams influence outcomes and strategies?
I can add a couple of points. I think similar to what Mr. Garcia said, what I've noticed on the criminal law side is that having a diverse representation in the office can help clear up maybe any misinterpretations or misunderstandings. For example, if you're reading through a transcript and there's a lay witness that's testifying, about their experience or, something that they observed, some of that information can be misinterpreted if you don't come from that particular culture or that background. So it's important to have diversity for those reasons. And then also to help potentially pick out any prejudice or biases that other people might not be able to see. And an example I can think of that is like jury selection. When you're going over the voir dire proceedings, and people from different diverse backgrounds might be able to say, hey, like something is not right here or in this area. So those might be a couple of minute opportunities where diverse representation is important.
And it's diversity not only racially, religiously, and these other ethnic organs, but it's experiential diversity. So, for example, in law school, because I did legal aid, we did a book drive for the Indiana State Prison, the main one. And then I taught a legal writing class to the inmates. I always say that's part of why I ended up on the Court of Appeals. I'm paying back for helping them learn how to write. But it made a difference because since I had been in a prison and had experienced it, teaching, and then I had a big case involving the Cook County Jail. Language matters. As you said, looking at what witnesses say, Beverly, experiences that those witnesses had, being able to read between the lines. I mean, being faithful to the record, but being able to explain it. And then the idea that the folk that you're deciding their cases, they see a diverse group of lawyers arguing and they see judges that are diverse, makes people feel better. I was thinking of this song, what is it? Can You Feel Me? There's that one song, Can You Feel? So when people see that there's someone like them, they have a sense that there will be an understanding. Does that mean that you abandon the law for all purposes because you can feel them, because you live those experiences? And so that becomes the driver of how a case is decided or how a case is argued? No, but there's an acknowledgement, a recognition of those differences that's respected, and that voice can be brought to the table.
I do, and this is, I don't know if I've ever told you this, Judge Williams, but I was in law school and you came to speak, and you were the first Black judge I had ever seen. And it was for the importance of representation and seeing yourself and realizing that there are spaces that you can achieve that you hadn't thought of. It is really, really important. Okay, so many of you have talked about this in your remarks already, that you've noted that many of the key civil and constitutional rights that we think of as being, part of our sort of the fabric of American democracy have been secured in appellate courts, including the Supreme Court. I'd love to hear more about the ways in which you have found personally engaging in appellate advocacy advances the interest of minority communities, marginalized communities in important ways. And I'm going to kick things over to Sopin, who has a really interesting experience very closely tied to recent events. So.
Yes, happy to talk about that. So I can actually think of two examples from my personal experience, and I'll start with the voting rights litigation that I worked on last year leading up to the election. And so I was very lucky to be a part of teams that litigated voting rights cases all the way from district courts in Wisconsin and South Carolina to the US Supreme Court. And here I'd like to point out actually that it obviously wasn't exclusively appellate work. I got involved at the district court level with writing motions for a preliminary injunction. And that brings me to a point about appellate advocacy generally for the law students who are listening to this, that, appellate practitioners in many places, including my law firm, can be involved with cases at the trial court level as well. So back to the cases, they challenge certain laws about absentee voting as unconstitutional during the pandemic. So as one example, some states require you to get another adult to sign your absentee ballot in order for it to count. And a lot of the laws we challenged had a disproportionate impact on minority communities. So in the example I just gave, there were statistics in some of the states showing that minorities were more likely to live alone. And of course, as we're all aware, the pandemic itself had a disproportionate impact on minority communities. And once the election was over, a lot of the efforts to throw out votes were again focused on minority communities. So as an example, in Wisconsin, the Trump campaign, the challenge was focused on recounts in only Madison and Milwaukee. So I really viewed these lawsuits as a way to protect a very fundamental right, especially for the minority communities that were targeted. And the cases were very exciting. They moved very quickly. In one of the cases leading up to the April primary here in Wisconsin, we had something like 48 hours to respond in the 7th Circuit and 24 hours to respond in the US Supreme Court. So those were incredibly memorable and very fulfilling experiences. And the second way I've been able to use appellate advocacy to advance the interests of minority communities is filing amicus briefs pro bono on some very important criminal law issues in Supreme Courts, both the US and state Supreme Courts. So I recently filed a brief on behalf of the Innocence Project about expert evidence on false confessions. And this was in the Wisconsin Supreme Court. In 2019, I filed a brief on juvenile sentencing in the Washington Supreme Court. And these briefs are, as many panelists have already said, an opportunity to explain to a rulemaking court why the law should be a certain way, not only in the case before them, but in future cases. And of course, there are all sorts of racial disparities in the criminal justice system. So I really thought of these cases as yet another opportunity to serve and advance the interests of minority communities. And of course, this is just the tip of the iceberg regarding the civil rights work appellate lawyers can do. So I will turn it over to our other panelists for more examples.
I just want to emphasize that really good point that you make, that because the impression is that appellate lawyers are in the dull side. It's not a lot of excitement that goes on. And I think more and more and more law firms recognize, not only in the area of civil rights, voting rights, and that kind of thing, when they're sitting down to do motions for summary judgment or motions to dismiss or motions in limine, what evidence should come in and what should not. Appellate lawyers are brought in because they can make certain predictions based on their research, based on what the courts have found. And so it becomes a very exciting, because I know when I started, it was very much siloed. The appellate lawyers were off doing their thing and the trial lawyers were separate. And now there's a recognition that you need appellate lawyers to be in the game, that you don't want to make mistakes at the trial court that really hurt you. So appellate lawyers really matter, and they help balance, to me, that desire of the client and the trial lawyer, which can often be so focused on winning and winning for the moment and not realizing the implications that it could total the whole case. So even if you have bad lawyering on the other side, and therefore you could take advantage of the poor lawyering on the other side, should you take advantage? Because will that in the long run hurt you or help you? Appellate lawyers can answer that question.
And I'll just jump in to echo that. You know, at our firm, and for me specifically, the thing that makes appellate practice fun and exciting is that you can be involved in all of these different ways. So this week, I'm getting ready to argue a criminal case in the Supreme Court. And then, yesterday I was providing input on a case for Warner Brothers about one of their movies that's in a district court. And the key is that you can work on anything, because your job is to think deeply, write well, and be persuasive. And actually, one of the best things about being an appellate lawyer is jumping into a new area, because your job as a lawyer is to explain it to a judge in a way that they'll understand when they're not an expert. So there's just so many different ways you can make a difference. And the one thing I would briefly say to touch on what Sopin was talking about is that, you can think about the thing that I love about appellate law is that you make law, right? You are always representing your client first and foremost, but you can also make law that is favorable for others. And that's just something you don't do if you're just in a district court. So before this morning, I actually looked up a Fourth Circuit case I had the privilege of arguing in 2018. It was a criminal case, and it established that a certain category of federal inmates could challenge their sentences. And we won that case, and our client got out of jail 7 years earlier than he otherwise could have been. But I looked earlier today, it's been cited by 189 other courts. And, if even a fraction of that represents other individuals who got out of jail early because of the time that our team put into that, that's just hugely meaningful. And it's something that you can only do as an appellate lawyer.
Well, I think you've all made the case for why diversifying the appellate bar is exceedingly important, both for law and lawyering and the profession. But one thing I see a lot on the law school side, and I've had the privilege of working in several different law schools and working with law students from many different law schools, is that particularly our underrepresented minority students often question whether they have the elite credentials that are required to pursue a career in appellate law. I often, when I was a law student and early on in my career, I thought unless you have a 4.0 and graduate from a top law school, which I didn't, and you got a fancy appellate clerkship with Judge Williams, the appellate law was not a career for you. And so I'd love to hear a little bit more about what advice you all have about how to help people realize these are careers that are accessible to you, that there are many ways to get there outside of sort of what we think of as the traditional roadmap. And with that, I'm going to kick it off with Beverly to talk a little bit more about that, offer some perspective there.
Thank you. I would first start off saying that if there are any students that feel concerned about whether they can enter into the field of appellate law, I would say, you know, if this is something that you want to do, go for it. Don't let anything stop you from what your dreams are, what your goals are. And then another thing I would add is for those who are concerned about what school you go to or concerned about your grades, which I was when I was in law school. One thing that you might want to focus on is other ways besides your school or your grades to build your resume. For me, I knew early on that I had to take a different path. So I focused heavily on developing the experiences that I needed. So I joined law review. I did moot court. I wrote articles for different bar associations, anything that I could do to develop my writing experience. And when doors closed for me, I found other avenues. So like when my article wasn't chosen for the law review, I wrote articles for the bar association, you know, anything that would help me to get the writing experience, and also getting experiences through internships. I might have had a struggle going from law school to getting a federal clerkship, but what I did do is I started off at the trial court level. So in law school, I interned with a trial court judge. And then right after law school, I got a job as an attorney editor for the Illinois courts. And then I got an appellate clerkship at the state level. So you might have to start from a different area and work your way up to get to where you want to go. So one way is to build your experience, and another thing to consider is networking. I did a lot of networking pre-quarantine when you were allowed to go to different events in person. Went to a lot of events, and even working, you know, being an attorney editor, I was able to communicate with all the law clerks in the state and, you know, get their perspective and their experience. So I would say, first, don't give up. And also, you know, you might have to do other things to help build your resume, like gaining some experience or networking.
I mean, I would absolutely agree to that. You know, don't do what I did. Say no to moot court, no to writing on the law review, because I didn't realize how important having that academic credential was. So you're right, Beverly. It's not just getting the top grades, getting the biggest honor in a particular course. Those, of course, will help you very much to get a clerkship. But all those things you're talking about, and working in the clinic where you can actually write, because that's what judges care about, writing. Can you analyze? Can you articulate? Can you write it? That all matters. So all that experience. The other thing to think about too is people often think, well, you know, I can't, you know, I'm not ready to take a clerkship now. And going the route you said, Beverly, taking other positions and then coming back to a clerkship. I would say there's anecdotally, definitely in the federal courts, a trend toward district and appellate judges hiring people who have experience, because you don't want to hire all people right out of law school. When I started, that was the norm. The norm was you clerked immediately after law school. That's changed so much. So it could be you're building your experiences those 2 or 3 years, or you could be at a big firm and you could have clerked at first, but people are coming to a big firm for 2 or 3 years or getting fellowships and going to big firms because they've got law school debt. Hey, we're talking about first generation, you know, your families have sacrificed for you to go and that kind of thing. Everybody's circumstance is different. But know that judges appreciate that experience and will hire you even though you're 2 or 3 years out. And it's a preference that many judges have, at least at the federal court. But I think you nailed it, Beverly. There are many other ways. And you can't just, there are other journals other than the Law Review. So, and then push to get your article published, or at least you get it written, because as I used to tell my clerks, your first year moot court brief will not cut it in your application.
I agree with all these excellent points and would just underscore Beverly's great point about networking. I think networking is a word that can strike fear in a lot of our hearts, especially as law students, and it's easy to kind of put your head down and focus on what's immediately in front of you, which is very natural. But you know, the reality is a lot of appellate hiring and recruitment is done within a very insular network of the appellate bar and who's adjacent to it. And for a lot of law students of color, especially those who are first generation and coming from communities where they're not in those networks already, you know, you have to just be proactive in making your interest known. A lot of our students will say, I'm embarrassed or feel shy about expressing my interest in appellate work, but don't be, you know, it's something that conversely, I hear from the appellate bar, are law students of color really interested in this work? We don't know. To which I say resoundingly, yes, very much. So, you know, don't be shy about making your interest known. And I think so many people will be very, very happy to talk to you. You know, reach out to folks. Don't be shy about sending someone a message and saying, you know, the work you do is very interesting. I'm interested in appellate work. Here's what I'm doing. Do you have a few minutes to chat, especially in this virtual environment? It's easier to catch folks. So I really encourage you to do that.
And that reminds me too, the appellate bar associations often will have student memberships. They put on programs and everything. Get involved in those organizations because people get to know your name and they get to see your interests. It really is important, that networking. And some people say, well, you know, you've given some suggestions on networking. Well, how do I even start the conversation? You know, I know this is like a big time appellate. Well, you do it the way you do any conversation. You know, so you research that lawyer. So, you know, they went to, I don't know, Michigan, they went to John Marshall, they went to whatever. So when you get on the phone, because some people have trouble with that, just that ice breaking, you say, you know, I noticed, I'm so happy we're able to chat because I noticed you went to John Marshall, I went to John Marshall, or, you know, whatever the person's interest is. Sometimes their interests are even in there. When you go to Google people, Google is a great tool nowadays for you to get background information so you can find ways that you can connect with people. And then it also shows that you've done a little homework before you call them or email them, and they're more inclined to say yes to you.
All right, well, I think that is a good, all of that is a good segue to the next question, which I'm going to direct to you, Javaria, which is you run an organization, you founded an organization called the Appellate Project, which is designed to think about ways and proactively address the concerns about lack of representation in the appellate bar. So we'd love to hear more about about the Appellate Project, how it came to be founded, and some of the initiatives that you all focus on.
Sure. So, you know, like I mentioned in the beginning, I came to appellate work a bit later on and was just struck by the lack of diversity in these spaces and the impact that that has on this work. And so it just got me thinking a lot about my own experience into the space, not knowing about clerkships, not knowing about appellate work, how that's true for so many of my colleagues of color. I started talking a lot to my interns, especially my interns of color, and just seeing the same patterns reflected again and again. really made me think a lot about the systemic barriers that often make it so difficult to get into these spaces. So I think at the outset, you don't know what you don't know. So a lot of these students miss out on appellate opportunities because they don't know about appellate work. They don't know about the steps they should take. As Judge Williams said, you're presented with so many options in law school. It's hard to know the currency of things and what you should be focusing on. And also just to see yourself in these spaces, right? To have someone who's encouraging you and saying, go for it, makes a huge difference. And if you do hear about this space and you see nobody who looks like you or reflects your background, it can be very discouraging. So all of that was sort of the genesis behind starting the Appellate Project. So we're a nonprofit organization. We launched this past September, and we have two programs. Our first is a partnership with Howard University's law school. Going back to the conversation earlier about civil rights appellate advocacy, Howard being the place where civil rights appellate advocacy was really incubated and in many ways, has such a unique voice to add to this work. So we're really excited to partner with their civil rights clinic to bring an appellate focus. We have two amazing appellate attorneys who run it, Tiffany Wright and Ed Williams, and the students work on civil rights appellate cases through the history of Howard's legacy. So it's been really great to see their growth and to see their interest in this work increase. Appellate clinics are such a valuable way to get substantive skills early on, but most appellate clinics are at a handful of mostly top-ranked law schools, not particularly diverse. There's never been one at an HBCU, so we're very excited about that. Our second program is our outreach programming. So this has a few different pieces. The main one is our mentorship program. Students around the country who are interested in appellate advocacy can apply and get matched with an appellate attorney as their mentor. And then, throughout the program, we provide additional resources to help give them the full set of skills that would help them navigate this space. So everything from clerkship guidance, brown bag lunches with judges, networking opportunities with the appellate bar, building those substantive skills we've talked about, like legal writing workshops, social events, just really trying to encourage themselves to see themselves in these spaces and have the skills and networks they need to hit the ground running if it's something they're interested in. We also do talks at law schools, especially trying to target 1Ls as they're entering law school to just explain what appellate work is. And if you're interested, be mindful of these opportunities that you might want to take advantage of. And then finally, we do events that are aimed at the broader public to highlight the importance of diversity in these spaces. And we really try to center the perspectives of attorneys of color who are doing this work, because I think oftentimes that's something that, when we talk about appellate work, it's presented as academic or sort of a legal issue that exists in isolation. But the fact is that it has, as we've discussed, an enormous impact on our everyday lives and often disproportionately impacts communities of color. So it's really important, I think, to underscore that, which is something that we try to do.
So if you'll allow me, Shannon, I want to be Javaria's Amen Corner. So I heard about her. I was so thrilled. I made a cold call, didn't I, Javaria? I'm like, I am so excited that you're doing this. This is so fantastic. And you all know I've been in the area of building pipelines my whole career. And so with just the beginning, a pipeline organization, and this helps at the appellate level as well, we have a summer institute, a summer internship program where we partner with the federal judiciary. And we had 200 federal judges from bankruptcy, magistrate, district, and court of appeals who registered to get a summer intern. We now pay a small stipend for that. We let Javaria's kids know about, not kids, I don't mean that, the young people, law students know about it because, we can work together. We can partner together on putting together programs and everything. And so what she's doing feeds exactly into what we're doing, which is the goal of trying to get clerkships. That's really important. And then, and Shannon is with me in the Jumpstart program that I started several years ago with all our local area law schools. Again, it starts 3 weeks before law school starts. It's a 3-day program. It gives students a jump start. So we talk about some of these options because you need to catch people when they go into law school, just like you're doing, Javaria, with these 1Ls, because there's so many interests pulled. And so, Shannon, we need to keep Javaria in mind. So when we do our jump start this summer, Javaria, we're going to ask you to, I know this is not supposed to be a recruitment program, but it just hit me because it's so important to get people when they're going in the first year, because you just don't know.
I would happily do anything Judge Williams asked me to.
That is how many of us function in the world. Judge Williams, whatever Judge Williams asks us to do, we're always more than happy to help out, because the work she does is so important across many different aspects of the legal profession, legal education, which I think, so we have, those were one of our formal panel questions. There are a couple questions in the Q&A, so I will want to turn to those. I'm going to jump ahead to the ones that are focused on from, I think, one of the participants about, asking why is there such a lack of diversity at the appellate bar, and we must, and reiterating that we have to understand the problem. I think, a lot of that I think has been answered a little bit by the panelists, in the sense of this isn't really a problem that's unique to the appellate bar, right? This focus of this conversation is, but in fact, there's a lack of diversity across the entire legal profession. And the reasons for that, I think, are deeply complicated. Some are systemic, right? Who has access to resources, who has access, what different access to education is, the quality education, who can afford to take LSAT prep courses, who can't, how many times can you take the LSAT, things like that, things along those lines. Who knows, who can get into what kinds of schools, who knows that going to schools matter. I applied to one law school. I was a first-generation college grad. I was first-generation law grad. I had no idea that there were rankings, and those mattered, right? Now I know a lot more about rankings than I ever needed to know. But again, it's access to information. And a lot of the work that I do with students is they matriculate into these spaces and they don't know things, they don't know about law review, and they don't know about appellate work. And then it's who gets mentored, right? And a lot of the conversations I have with our faculty is, if you see someone is doing a good job, or you see that they have potential, tell them that. There was a study recently about women of color faculty members in legal academia. What they found was that all the women who of color had been interviewed only ended up in academic careers because someone told them they should consider it. They themselves never considered it, because when you look at the law faculty at almost any law school, they are predominantly white and they are predominantly male. And so they don't see themselves in front of the room. They don't see it as something that's accessible to them until someone tells them that. So I make it part of my job in my capacity, in my role at Northwestern, to tell our underrepresented students, you should consider a clerkship. You should consider this. What are your skill sets? And oftentimes they're like, well, that's not me. That's, someone at the 4.0 from these things. It's like, no, you do have access to these opportunities. So part of it is, again, systemic, who has access to these spaces and these opportunities, who is, mentored, and also, who is helping people realize that these are things that are accessible to them. So I think it's complicated. A lot of the work that Javaria just described and Judge Williams are talking about at sort of all levels of legal education are designed to try to address both the systemic and the very real role that I think bias plays in individuals' interactions. But I don't know if there are other.
Let me just comment, Shannon, on this. In addition to Javaria's terrific work, there was a new not-for-profit started in this last year called Dear Future Colleagues. And that was something started by former law clerks. It was actually started by law students. And the idea is to focus on undergrads to get them ready to go into law school. And they're getting mentored and they get advice on when to take the LSAT and all that stuff, that if you come from a family where they're lawyers or judges, where they can give you all those tips, then, you can go on, you don't need to get engaged in it. But if you're first generation underrepresented person of color, it makes a big difference. And they're based on the same premise as Javaria, which is to provide mentorship and guidance. So everybody gets a mentor. They have different programs that they work with. And of course, we work with them at JTB2, letting them know what we're doing. And there's one other one. It's called, what is it called, Javaria? Is it the clerkship? You know, the other one that's focused on clerkship mentoring. What's the name of it?
Law Clerks for Diversity.
Yeah, Law Clerks for Diversity. Another organization started by law students who saw the lack and started an organization. Again, it's all about mentoring. They try to get in first year, but they'll do second and third year. They have projects, they do programs. So those organizations, you know, terrific. And they're going to help, I hope, change the paradigm, change the future so that kids are prepared.
All right. Any other thoughts on, I think the really important question is why is there such a problem with diversity in the appellate bar?
I think just to piggyback on what everyone else said, a part of it is the lack of knowledge, not knowing that there is this area out there that you can, you know, work in. And just to point out what Judge Williams said, I didn't know about the programs that she was talking about, but the programs that were available to me, like MLER, which was helping people of color study for the bar exam, or at my law school, they also had a bar prep, and they had different things to help people of color. And I took full advantage of those opportunities when they were available to me. So I think it's mainly because of lack of knowledge. And it's great that there are programs out there to help people of color. And I know that those people, once they know about them, would be taking full advantage of those programs.
And let me just comment on one other thing too, Shannon, the whole confidence thing, the whole headset that first generation people of color come into an underrepresented group. Some come with confidence, real confidence and belief for whatever reason, because everybody comes from different backgrounds, and many people, or a number of people, do have lawyers and judges and everything in their families and can give them the real deal. But some people come sort of knowing what our society is like and feeling very self-conscious about being first generation person of color, underrepresented. And somehow, because of attitudes perhaps of some of their classmates or faculty, feel like they don't deserve to be there. You know, we've talked about that imposter syndrome. And so headset really matters. And so I say to those students, okay, the person next to you, perhaps their mother or father was on the faculty. And 2 doors down, 2 seats down, that person, a donor. Or maybe the person behind you is somebody who's a veteran. Or maybe 2 rows back is somebody who grew up in a farm town in Idaho. Or someone who has been in the, you know, the Teach for America program. Like, to me, all those different characteristics, those are the chits that help get people in law school. So if one of your chits happens to be that you're first generation or you're a person of color, your chit is just as good as all those other chits. You deserve to be there just like everybody else. And so you can't let the attitudes, racist, sexist, misogynistic attitudes of faculty or students hold you back. Because often, to me, people in that category, you can defeat yourself by saying, you know, I could never do that. I'm not smart enough. I'm not good enough. I'm not. We have to get over that attitude and realize that you deserve to be there. The law school would not admit you if they didn't think you could do well and you could succeed. But what law schools also have to do is provide support for people when they get in law school, when they need more assistance, not because they're not smart enough, but because they just haven't had the exposure.
I do think that's an important point. A lot of the students that I work with say exactly what you just said, which is that I don't think I'm supposed to be here. I think there's a mistake. And frankly, they get a lot of they have a lot of experiences in the community, whether from faculty or staff or students,
Right.
that says you're not supposed to be here.
Exactly.
And so it takes a lot to be able to navigate that, and then also have that confidence. No, I deserve to be here, and that's something that I know we continue to work with, and I think Jumpstart does an important part, plays an important role in that. So I know we are getting to the end of the time, so we have a couple questions that hopefully we can maybe answer quickly, because I don't know if we have answers to them. One is that someone says, are there resources available for diverse judicial candidates who are seeking election to the appellate bench, considering the expense of such elections? I don't know if anyone has any thoughts on that.
See, since I was on the federal bench, I didn't have to deal with the state court. I know there used to be a coalition in Illinois, but I think this is for judges who are already on the bench, where they would join together, like maybe 20 or 30 judges. So when they're doing the campaign funding, the money just goes into that sort of coalition. So the judges aren't in a position to ask lawyers, would they donate? But I'm not aware of, I'm just not aware of it. But there's certainly judges organizations like the Illinois State Judges Association, the Illinois Judicial Council, which is primarily African-American counsel, where you can certainly ask and inquire. I just don't have that knowledge.
Okay. All right, looks like we also have a question about any advice to give to a young attorney in a private law firm about developing a business case for their promotion within the field of appellate law.
I can try to give that a shot. I think, and I saw this question as well, and talking about how maybe the economics of appellate work is, not as conducive at a private law firm. But the real answer to that is, what I and Judge Williams and others were saying earlier, is that really what an appellate lawyer is and can be at a place in private practice is a very good writer and a clear legal thinker. And you need that on every case and at every level. So if you can develop a reputation and a set of skills as a good writer and someone who can learn new areas quickly, I think that is a reputation that is valuable for law firms and very helpful to clients.
And just to piggyback on that, as someone who's also at a private law firm, I do find that practicing appellate law, being a good writer, has allowed me to meet lawyers in all different practice groups. So I will work with partners in privacy or partners in products liability. And the advantage is that you just get to know many leaders at the firm. And when the time comes for partnership decisions, you can leverage your reputation and sort of that reach that you have across the firm to make the case for your partnership. I will get emails, random emails from people whom I've never met or seen before at the firm, saying, so-and-so said that you helped them with this particular appellate issue or this particular brief. Can we talk through this quick issue? And then that discussion will lead to helping in future cases. And I think, yes, as Brad was saying, really selling yourself as a clear thinker, someone who counsels internally and externally, can really make the case for partnership.
And I think making yourself available for pro bono opportunities, that's an area that there's a lot of work, because organizations will write, like the ACLU and different organizations that may need help from private law firms to help fund certain appellate litigation. So sort of knowing that and knowing those organizations, those are organizations that you can develop a relationship with, and that sometimes opens up those kinds of opportunities. So that's just another way to sort of get at it if you're in a firm. And obviously you want to, if you can, go to a firm that has an appellate practice. That's but some of the firms that with appellate practices, speaking to your point, Brad, are a lot of the appellate practices are filled with people who are former Supreme Court justices, but have worked for a justice on the Supreme Court. But then they're a number where it's appellate judge, the appellate clerkships they've had or district clerkships they've had. And if you're a strong writer, I mean, to even go and volunteer to the appellate section and say, you know, what's the situation? Are you all over? I'd be happy to be a second. Is there any way I can get on this brief? Because this is something I have an interest in. You know, you have to be aggressive and stand up for yourself. If it's something you want, you have to figure out a strategy to get it. And so if it means you have to go to your supervising lawyer or whoever is head of your practice group and say, hey, I'd like to develop some appellate skills. Would you mind if I went over to the appellate practice leader and, assuming I don't have work that I need to do for you, that I volunteer to work on, you know, pro bono or whatever, do it.
All right, so we are at the end of time, so I think that means we're not going to be able to answer the remaining questions in the panel, and I apologize for that. But I want to thank all of our panelists for joining us today for what I think is a very important and valuable conversation. I want to thank all of our co-sponsors, ACS National, all the ACS chapters, all the Northwestern law organizations that also co-sponsored the program. We do hope that you take the very important message that we do need to diversify the appellate bar, and we hope that all of you will not take yourself out of running for those opportunities. The message, I think, has been one of resilience, perseverance, don't give up, really put yourself out there. I'm sure everyone on the panel would be happy to talk with you if you have further questions. Feel free to email us. This was recorded. I believe that it will be distributed. Thank you all very much and enjoy your afternoon.
Thank you, Shannon.